Family disputes can make us feel isolated and vulnerable. Maybe you're going through a divorce or a legal dispute about your kids. Perhaps you've spent hours on Google or have even posted anonymously on Facebook to see what others have to say. But are you getting the actual information and support that you're looking for? Our podcast, Legal Lounge, aims to dispel misinformation and downright bad legal information to empower anyone with questions about their family, their children, their finances, their marriage, and the law. As a team focused exclusively on family law matters, we aim to help listeners not only with the information they need, but also with the hope that their situation has a solution. Short disclaimer, please note this podcast is for educational purposes only, and the information should not be relied upon as legal advice or for legal purposes. Welcome back to the Legal Lounge. Today I have a colleague of mine, but in the business law realm, a friend of mine named Shawn. Tell us a little bit more about yourself.
Hey, Theresa. Thanks for having me on. My name is Shawn Garrett. I'm the founding attorney of Garrett PLLC. I have 2 little boys and a wife here in Matthews, North Carolina, just outside of Charlotte. My focus is on business transactions, whether that's forming, the sale or purchase of. And that's a little bit about me. I like to run. I'm a big outdoorsman. So
Nice.
If I can be outside, that's typically where I'd prefer to be.
I need to make it outdoor more so, but it doesn't help when the weather is 70 degrees and then 30 degrees like it happens here in North Carolina.
So tough. I like golfing as well. And I was talking to a colleague yesterday and he said, Shawn, you're the one person that texts me in December when it's 40 degrees out to go golfing.
So
It's just
you'll
another
do it
day.
no matter what. That's
Exactly.
fair.
Just another day.
I love that. So I know you bring a similar enthusiasm to your practice of law, specifically business law.
Mhm.
Can you tell the listener, what does business law encompass? Like, what does that look like to your average person who doesn't know much about the law?
Yeah, great question. So initially we're starting with what type of entity are you going to form? But even before then, that's typically when people come to me, I ask them, what are you going to do? And you'd be surprised how many times that conversation stops people in their tracks. For attorneys like you and I, where we run smaller firms, we have the flexibility to be able to tell people, at least in my shoes, let's go back to the drawing board.
Mhm.
I had to tell a client one time, I don't believe that you have the right vision or idea yet. I don't want to create an LLC for you just yet because I think that there may be some corporate governance processes that you may not comply with because you're still trying to figure out what it is you're going to do. So we have that initial conversation. Once they're over the hump and we feel confident in their vision, we form their LLC or corporation, however we decide to proceed there. We discuss tax structure, which I do not purport to be a tax expert, but I know enough to be dangerous. So
Yeah.
we discuss taxes, and then from there, we form some of their more crucial documents. I start with their operating agreement. And then from there, we have the conversation regarding adding value to their business. Some of the most important documents for me that I advise them on are going to be their client document, whatever that document looks like, whether it's an engagement agreement on their part, or some type of vendor agreement, third-party agreement. Because one day when they go to exit, which is what everyone wants to do, they can then take those documents and show the potential purchaser, this is my value. I've engaged clients for 6 months, 12 months, and this is value that you can proceed with. So I try not to overlook that step. Everyone's very excited about the very initial getting the business formed, but then I say, let's add value. So little ramble there, but then from there, I help people with buying businesses, selling them, and dissolving them if needed.
Very interesting. So there's a lot there. I know you summed it up very well,
Thanks.
but those are a lot of different stages. And so
Yeah.
some of those stages could take weeks or months just in that initial formation,
Mhm.
possibly even longer if you tell them, hey, pause, rethink this whole situation,
For sure.
which I appreciate. And we've both formed our own companies, and I get it. I'm a lawyer. I love the law. I still prefer to talk about my firm colors and our logo and all the fun stuff
Yeah.
that comes along with a business. But it's critical, really, to think about these documents because they're going to be the everlasting documents that dictate what you can and cannot do moving forward.
Definitely. Starting off on the right foot is what I tell
Mhm.
people. A lot of people want to just get something open quickly so that they have something to show people or
Mhm.
post on social media or whatever it is they want to do. Coming up with the brand colors, the more exciting part of the
Mhm.
business. But then I tell them you're going to start moving too quickly. You're
Mhm.
going to bring on a partner. You're going to bring on an employee, and the next thing you know, you're not going to have those governing documents to modify off of. You're going to be starting from scratch with a business change or a transaction having already taken place without even having the receipts at the bottom.
Well, in family law, we see people rushing in to marriage
Hmm.
a lot.
I'm sure.
And they too, unfortunately, don't always get their documents in place or understandings more so.
Hmm.
So a lot of people understand you have to have a marriage license, but very few people even talk about the prenup. And in a way, it's similar to an operating agreement.
Very much
It's
so.
just governing how you're operating your marriage versus your business.
Hmm.
So tell us a little bit more about operating agreements because I feel like that's where you can almost get the most creative.
Yeah, certainly. So when it comes to the family law intersection of business, I would say the operating agreement is really where that intersection takes place, especially when it comes to either a married individual getting into business with someone else that's
Mhm.
married. Now, I just want to be transparent. Not talking about people married to each other.
Mhm.
They end up having spouses, but they're doing business with one another. But then on the flip side, we talk about spouses doing business with one another. When we have the first scenario where we have married individuals whose spouses are not involved in the business, we start talking through dissolution. And I
Mm.
know it's interesting to think about how or process why are we talking about dissolution before we've even formed. Well, we want to know what's going to happen with that business interest at the time of dissolution. Now, again, I know just enough about family law to be dangerous. You could
Yeah.
fill in some gaps here. But when it comes to LLC interest in North Carolina, that is
Mhm.
considered marital property.
Mhm.
And so at the end of the day, we want to try to either prevent or account for that interest if there is a death or divorce. So I do write into my operating agreements that there is a right of first refusal for that is triggered with a divorce or a death. What do I mean by that? If there is a divorce or death and both parties in that relationship agree, where again they're married to individuals but not to each other, but they're in business together, the other party has the ability to purchase the other member's interest. And
Mhm.
I think that that's a very strong tool because you don't necessarily think day one that you want to have two other managers of the business or two other owners of the
Of
business.
course.
And so I try to at least address that early on. Now, sometimes they say, we're not that concerned, everything's hunky dory. And then we circle back to it years down the road. But initially, quite a few of my clients take me up on that. And we put in provisions to account for what the value is going to be and things like that.
Yeah.
Now, when it comes to spouses, more of the conversation is focused on day to day management versus long term management. I have honest conversations with them regarding who is going to have hiring and firing abilities, and they typically say, "Well, we'll both get involved in that." And I'll say, "You say that now, but when one person's running around with the
Mhm.
kids and the other person is, running the business, someone's going to be frustrated. It's either going to be the individual running around with the kids that feels like they're not involved with the business, or the person running the business that feels like they're just not at home with their family and they're being forced to do the work." And that's two sides of the same coin. Both parties could be frustrated while not seeing each other's point of view. So let's get it out early. Who's going to do what? And let's document that in the operating agreement.
And I'm sure you discuss with them like this operating agreement is there in the just in case scenario
Yep.
because maybe when spouses are hiring someone, they agree they both want to hire this one person.
Yeah.
It's those points where you don't necessarily agree, and to
Hmm.
your point, you're just taking on different parts of supporting a marital relationship. So let's just have a final decision making authority
Yeah.
here. Now, I will say on the flip side, and going to your earlier scenario
Hmm.
where you have business partners and they're each married to someone else.
Hmm.
Um, that is a perfect opportunity, I would say, and actually, even when spouses are in business. But I'll start with this first example of what we call a postnup. Now, if you don't have a prenup, which we can address any future hypothetical business interests that are created or assumed during the marital relationship, are owned by one or the other party, or possibly even both in that prenup. But let's fast forward. You don't have a prenup. We could do a postnup, and a postnuptial agreement is somewhat similar to a prenup. However, postnups generally are more targeted. So they could be, oh, wait, wife wants to enter into a retail business with her best friend. Okay. And husband's like, cool, I just don't want to be liable for any debt. And you know what? If you make any profit, good for you. Should we separate? That's all yours, free and clear. I just don't want to take the risk, the same risk. We can do a postnuptial agreement in family law so that it does become said spouse's separate property and liability should a separation or divorce have occur in the future.
Mm,
And it's not necessarily just there in the event of separation and divorce, but it's also there to dictate how it's going to operate during the marriage itself.
mm,
Because if husband, for example, says, hey, I don't want any part of it, then wife can be like, okay, I'm going to put that in my operating agreement or partnership agreement that you were referencing a moment ago,
mhm.
and go one step further. What if that partnership wants to do more than just that retail business? Maybe they want to open a spa. Maybe they want to buy real property. And suddenly that spouse does have free authority, free reign, if you will, to make those changes. And I hope they still are saying, hey, honey, by the way, I'm going to be at the office late. But then the other spouse doesn't have to worry about the marriage or their personal credit or situation being impacted by these business ventures and risks.
Mhm. Question for you. Now, I know
Sure.
it's your show,
Oh,
but I
no, come
want to
on, bring it
fire a
on.
question back.
I love
I
it.
know one of these answers, but I'll ask it broadly and then let you address it. When it comes to the pre and the post nup, in law, as you and I both know, you need consideration or some type of exchange
Mhm.
for the agreement to be valid. What type of consideration do you put into a prenup and a postnup?
Well, and it's interesting because consideration for spousal agreements
Hmm.
is not the same consideration for a regular contract.
Well, there you
That's
go.
why there's a different umbrella under which spousal agreements have laws, and it's more so the situation where the consideration is the continued relationship. So, for example,
Mhm.
for a prenup, the consideration is, "Hey, I'm about to give you my life," right?
Yeah.
With that giving of a marital promise, that promise to marry, the vows, if you will,
Mhm.
I just want our marriage to be structured in a way different than what the state laws dictate.
Mhm.
So some more similar to like a will. If you don't have a will, the state laws are going to apply to your estate. Same thing for your marriage. Unless you agree before the marriage as to what those terms will be in the structure of your marriage, as well as the structure of any separation or divorce that could occur, the state laws will apply unless you have a prenup stating otherwise. For a postnup, you're dealing with a different set of laws than you are dealing with in a prenup because you've already made certain promises when you said I do. And when you say I do, you're not just saying I'm going to marry you for the rest of my life. I'm making certain marital promises to you.
Mm.
That includes the promise that I will be faithful to you and you alone, that I will be there to help support you emotionally, mentally, as well as financially. And because those promises have already been assumed at that moment, exactly when you say I do, a postnup has to take those vows into consideration.
Mm.
And so, a postnup, that's why I say it's rather targeted because with those agreements already in place, you're making an adjustment to those agreements. So
Okay.
it could be, we're joint property owners of any property interest. Oh, wait, someone wants to open a business, then the business itself, which is treated as a form of marital property otherwise,
Mhm.
let's go ahead and define that that piece of property will actually be considered someone's separate property and liability moving forward.
Okay. That helps out tremendously.
Yeah,
Thanks.
yeah. It is tricky. It is tricky, and,
It
and it's
is. Yeah.
interesting because, I like contract law.
Mhm.
It's funny. I like to say my best grades in law school were real property and contract, but I practice more civil procedure than anyone
Yeah.
across the board because family law is very civil procedure intensive.
Yeah.
But it's just a slightly different world
Mhm.
that the law has created for our families. We still have room for improvement, I will say that, but it is its own little bubble.
That's awesome. Well, you know the way I think, very contract driven.
Sure.
And so, when it comes to having those attorneys with different specialties, that's why we get people like myself, yourself, state attorneys all in the right rooms because it really is a circle. I'm only advising on a quarter of the circle, and you're advising on probably more than a quarter. I'll give you a third of the
Oh,
circle.
thank you. You're too kind.
but exactly, that's why we all get in the same rooms and have these
Yeah.
conversations. So
Yeah.
that's awesome.
There's no conversation more romantic than discussing a prenup with your partner, right? Okay, maybe the song for your first dance does a bit more in the romance department. Speaking of emotions, though, the prenup is a very legal document that everyone has a very emotional reaction to. Many people avoid the prenup conversation because they feel it is an indication that the marriage will fail. But here's the truth: half of all marriages already fail, regardless of whether the spouses had the prenup conversation or not. If you or someone you care about is getting married, would knowing what marriage involves legally be important? What about having the difficult conversations surrounding finances, career aspirations, and pursuing parenthood prior to the wedding date? If you are looking to build a solid foundation for your marriage, or you want the same for someone you care about, we are here to help you learn more about prenups from a position of knowledge, not emotion. To learn more about family law from a legal professional, book a consultation with a member of the Modern Legal team by visiting our website, emailing us, or calling us at 704-286-6302. Check out the information about Modern Legal services at modernlegalnc.com.
Some of the other things that I chat about when it comes to the operating agreement, capital contributions. Sometimes individuals want to get creative with that. And, when it comes to the vision and having management conversations, who's going to be doing what, parties will try to exchange time rather than funds, and they'll value their time at some type of dollar amount. And then the question comes up, well, he or she did not put in their time and effort. They did not do as much work as I put into the company. And so we try to build out for that early on by stating that time must be documented and it must be delivered by a certain date. Just to make it a little bit more palatable there. And then we get into transfer of ownership interests because even when it comes to married individuals, one of them may want out and they may want to transfer their ownership interest. And when parties are disagreeing, they could sell it to whoever they want. So we try to accommodate for that as well in the agreement.
Yeah, that's fair. And I feel like there is some overlap there because a contract can be established between spouses.
Hmm.
And I feel like the average person doesn't realize you've actually signed a really, really, really long contract when you say I do.
Hmm.
So it's particularly important that if spouses do get into business together, that they have a well drafted operating agreement uh, for all the what ifs that could present themselves, especially in a business.
Yeah, yeah, certainly. One of the other things that you and I talked about very lightly was what happens if one spouse wants to get into business and the other spouse doesn't. However, a third party is forcing the spouse, the non-interested spouse, to get involved with the business in the form of a guarantee.
Mhm.
A guarantee is a personal pledging of an interest in whatever the document is. Typically, I see them in commercial leases and franchisor agreements. So I'll paint the picture with the franchise example. Let's say that my wife wants to open a Steak and Shake. And
Mm,
when she goes to Steak and Shake and says, let me buy into this franchise, they tell her one of the conditions for us issuing you the franchise is that your husband must join as a personal guarantee on the franchise agreement. And one of the reasons there is if the franchisee, the person getting into business with Steak and Shake, fails or does not satisfy one portion of the franchise agreement, let's say that they're not paying their share of gross sales or profits weekly, then the franchise wants to come after them personally for those debts. Now, a lot of times in North Carolina, at least when it comes
mhm.
to real property, people can get around having their at least. Now I'm getting a real property law, but they can have their primary residence kind of shielded from that if they are the only one that entered into that contract. However, franchises, they're a little bit more clever and they've said, you know what, we're going to have the spouse join in to that agreement as well.
Mm.
Unfortunately, that's not a very big negotiating point with franchises.
Yeah.
If it's a new franchise, sometimes I can push that across the finish line and say, let's increase the franchise fee or do something to try to get that moved. But If it's an established franchise, Chick-fil-A is not listening.
Yeah.
McDonald's not listening.
You accept or don't accept.
Exactly. But it's a consideration. And it's something
Yeah.
that people don't realize when they first have those conversations with a franchisor, or even in a commercial lease situation. I've had a few clients that I've advised on commercial leases, and I wouldn't say it's 100% across the board. I think I'm probably at 60-40 currently with commercial leases that want spousal guarantors. So I try to prepare people for it early on, but it's difficult when you just don't know what what I keep saying franchise, what the landlord really wants to see.
Yeah.
So that can also stop commercial leases in their tracks. And I've had a number of clients who have said, one, my spouse won't sign on, and I've had even more clients who have said, I don't want to ask my spouse. I'm not going to ask them to commit.
Well, here's an idea.
Okay,
And maybe this is a new partnership that we're creating via this podcast.
I like it.
I am happy to assist on, the idea of a postnup, such that maybe that would also sway the negotiations one way or the other, because I can completely understand that the spouse that is not running the business or needing that commercial space, wanting their name attached to it.
Mm-hmm.
I mean, I feel like me and my husband, granted, we have a prenup, but me and my husband, there are times where we specifically discuss, like, okay, we will consider this an expense that can go on the joint credit card. However, those other expenses need to be on your separate credit card,
Mm-hmm.
because I don't want to be liable for them.
Yeah.
And it's not as a means to, any negative ill will. It is just the boundaries that we're setting, because we both want to have the freedom to work together in certain projects, but also the freedom to work separately in other projects.
Mm-hmm. Would the postnup keep the spouse from signing the agreement, or would they still sign the agreement and then it protects them on the back end? How does that work?
I think it would depend on how the operating agreement for the business is.
Sure.
So if, for example, we have a postnup that says, and I'm just presuming a husband-wife situation, husband opens a new business, and that business is formed into an LLC, and the parties sign a postnup, the spouses that is, sign a postnup that says wife has no interest in this LLC, it's husband's sole and separate liability. At that point, when he goes to, say, negotiate a commercial lease space, and they say, oh, we need the personal guarantee of your spouse, I think they could present the postnup and say, well, that's not possible because my spouse has no interest in the business, in this commercial space is for this business.
We're going to try that.
Let's do it.
We're going to try it. I like that a lot.
Yeah.
Cool. I like it.
Yeah.
That's what we do, right? We get paid to, be creative and think outside the box. That's awesome.
And I think that's important for the listener to hear. To literally, we're kind of discussing legal strategy, even though this podcast is for educational purposes only, because we do want to make sure we use all the tools in the legal toolbox, if you will, to benefit our clients.
100%.
Because there's always going to be someone who is fighting for their own interests, and rightfully so, because I'm sure that commercial space, they have their own interests because they have their own bills to pay and property to upkeep. And so they want to make sure they get their rent.
Of course.
Which we understand. On the flip side, we're representing our clients and their businesses and their spouses. So we want to make sure we're combating those commercial entities or any real entity out there. I always like to say, don't sign anything unless you've reviewed it with an attorney. And it's funny because side story. I was recently asked to provide my consent for a recording, and my lawyer face dropped real quickly. And the person asking me for it was like, whoa, okay, now I'm going to have to explain myself. And I did. I wanted a full explanation. And I think that's valid for anyone who knows that there are further legal implications with every signature that you sign.
100%. And with AI, it's becoming even more intimidating, at least for me. I partake in quite a few small business M&A transactions, business purchasing or selling. And typically an M&A attorney will get involved after the letter of intent is drafted. Now that's from small business all the way up to large corporations, just because a broker or the parties themselves can engage in the LOI, and it's generally non-binding. Not it's not a binding document. However, I have seen some LOIs that have AI that were drafted by AI that said this is intended to be a binding document.
Mm.
And it's just intimidating what's going into these documents at this point. If someone were to draft an LOI via AI, they're not going to know, typically speaking, not speaking for everyone, but if it's their first transaction, both parties likely wouldn't know that it's not intended to be binding. And if they accidentally made it binding and then they're not in agreement, if both parties took it to their individual attorneys, one attorney would have a leg up and say, heck yes, we're sticking with this. And
Yeah.
hopefully I'm on that side.
Yeah.
But if I'm on the other side of things,
Yeah.
yeah, it's intimidating.
Your
So
client shot themselves in the foot, not realizing it.
exactly.
And we've seen that a lot when individuals are, and this is AI and before AI, where people want to draft things their own way and they believe that they're doing themselves a service by not incurring legal fees or incurring the time that it takes to work with an attorney because we are so thorough and it
Mhm.
takes a moment for us to get through everything and do what's best in advising as well as drafting these documents. But there was an example the other day in a continuing legal education course that one of my friends put on, and it literally was about how anyone with at least 30% ownership of the business in some way, shape, or form could basically sell the business.
Mm,
Well, there are only two partners.
mm.
So that meant someone could sell it from under the other person if they
Yeah.
had a 30% interest.
Yeah.
Now, such a provision may apply when you had 10 people with everyone less than 10% ownership and you just needed at least 3 or 4 people together to sell the business. Makes more sense.
Mhm.
But that's the conundrum here, right? Because there is no one size fits all for every legal scenario presented to every person,
Agreed.
and hence the need for attorneys to be by someone's side going through these contracts and drafting these provisions.
Yeah. In a commercial lease I was reviewing, rent was $2,000 a month. The annual rent was $60,000. Now, attorneys are not great at math,
Yeah.
but I run all the numbers whenever I
Yeah.
see them.
Yeah.
I get out the
I'm
calculator.
thinking about that one. No, I'm doing it. Doing it in my head.
Yeah,
Give me a
exactly. So
second.
yeah, I tell her I'm not great at math, but I've got a calculator, so we're good. And I'm running them, and I say, well, I like the $2,000 number. I don't love the $60,000 number. That's
Yeah.
$5,000 a month. So just quick editing of a lease, something got glossed over. We were an afterthought. Truthfully, they said, hey, Shawn, review this. And typically, when I receive a document like that, clients will say, quick, review it fast and cheap. How much is it going to cost? I typically tell people you can choose two of three. You could choose fast, you could choose cheap, and you could choose wrong. Wrong's
Mhm.
not an option because I'm not putting that on my malpractice insurance. So fast or cheap, you're not getting both.
Mhm.
And so at the end of the day, I go back to them and I say, this is an example of why it takes time. I need to spend some time with this document because if I was reading through it quickly, I would have missed that as well. And
Mhm.
it's just not an option. So
Yeah.
really educating people on what it is that we do. And
Yeah.
it does feel good. I'm sure you've experienced this when you catch an issue like that,
Yeah.
you've saved someone $30,000 and you can move on.
And I'll toot my horn here.
Okay.
I've saved my clients a lot more than
I like
$30,000,
it.
and I say that not necessarily in the cases that we settle, because my hope is that if a case is going to settle, it will likely settle whether it's before you file the complaint with the courthouse or at the courthouse, the door entering the courtroom, right? And so it's just a matter of time. So yeah, I'll save you money if I can get it done sooner.
Hmm.
On the flip side, especially with my prenup clients, if we can get a premarital agreement in place, we're talking sometimes hundreds of thousands of dollars. In one case, I remember at least millions of dollars we
Wow.
saved my client. And I say that because if you have an understanding at the front end of a marriage, you got to formalize it in a prenup, have everyone on the same page, be agreeable to whatever those terms are. Because on the flip side, we can use that prenup, and we have effectuated and deployed, if you will, the
Mhm.
prenup and the provisions therein in a separation and divorce. And it saves both sides that hundreds of thousands of dollars, possibly millions,
Mm,
especially depending on how certain assets grew
mm.
over that time. And there's sometimes you just don't know at the date of marriage how things are going to grow. But if you can say that it's going to be separate property, then you don't have to worry about it being exposed to equitable distribution in the divorce side.
Yeah, I like it.
Well, don't I have bags, literally. We give out these at wedding expos. Ask me about my prenup bags. I'm
Okay.
happy to grab you one too, Sean,
That'd be awesome.
with that interest.
I like it. I appreciate it. I appreciate it.
So, Sean,
Yep.
conundrum here. Let's say we have a couple and they're in business together and they've been relatively good partners in this business and they have an operating agreement. So we do have, one spouse taking the lead on HR decisions and maybe the other spouse taking the lead on financial investment decisions and so forth. And unfortunately, there comes a situation where they decide to separate and divorce. What has been your experience in dealing with such a change of status, if you will, a legal change of status?
Yeah. First things first, we'd look at the operating agreement,
Mhm.
and I would really hone into some of the dissolution conversations that we had initially. I'd want to make sure that both parties were still okay with sale provisions, because I think it's easier to prevent a sale when your spouse wants to sell their interest versus if then you become unmarried individuals and one party has a disagreement, then they could truly sell it to someone that you have no interest in doing business with. So first things first, I dive into the operating agreement, and then from there, quite a bit of my job ends up being counseling in some way, shape, or form. I would have honest conversations regarding roles again and vision and whether you can do business with one another. If there were two individuals that had just gotten divorced that were still doing business together, I would probably ask them who their employees were, who their right hand man was, and I would, depending on if they were interested in this or not, I'd probably propose a third party, or not a third party, a third voice to be a manager or someone to split decisions. Because when they both have 50% management say, I'm anticipating a world where they're not in full agreement all the time.
And I would hope that although parties agree to separate and divorce, that they can work together well. As you can imagine, though, I don't always see that side.
Hmm.
Actually, I very rarely see that side.
I believe it.
And so, generally, what I see if parties are in business together, and yes, we try to bring in a business law attorney at some point to really go through some of those exact items you mentioned a moment ago, but figuring out what is the plan in terms of equitable distribution.
Mm.
Because if both parties were involved, both spouses, and therefore this business is part of the marital estate, and yes, okay, the business itself could continue to operate jointly moving forward, but who has ownership?
Mm.
That is a number that generally a court will give to one person or the other.
Interesting.
Now, if we don't want a judge to make that determination, then we do have to get creative, and we can get creative outside of court.
Hmm.
But generally, a judge has very limited authority. And specifically for equitable distribution, including a business, it's classification, whether it's marital or separate,
Hmm.
what the value of that business is, which is very hard to value businesses, as you know,
Hmm.
until it's actually sold.
Yeah.
And then third, who gets it? And the who could either be possibly selling it
Hmm.
or it going to one party or the other. I actually haven't seen it. And maybe some other family law attorneys want to chime in and give me a call after this podcast. But I have never seen it where a judge will say, okay, the two of you can continue owning this uh, marital property together.
Interesting. It's
Mhm.
obviously a different world, not a world I'm
Mhm.
exposed to a ton. The times I've been exposed to it, it's generally the parties coming to an agreement outside
Yeah.
of that relationship, or the divorce, I should say. And then typically it would go to one spouse or the other, but they've already come to terms with that
Mhm.
outside of me. I have seen situations where the spouse is, profitable business and they want to continue both working in it. That was one time. But yeah, it's interesting with the fact that it's out of their hands at that point.
Yeah.
It is in a divorce proceeding. So
Yeah.
I appreciate your feedback there.
Yeah, and I will add that those divorce proceedings and the equitable distribution specifically proceeding really is to take a entity, i.e., the marriage, and
Hmm.
divide it. Because what I like to describe it as is when you do get married, you have spouse one, spouse two, and the marriage. So it's actually three entities at that point.
Hmm.
You're just dissolving that marriage piece.
Got it.
Now, that doesn't mean that you can't continue to own the business together or operate otherwise.
Hmm.
But if we have to resolve it in equitable distribution, then the courts are going to do something that maybe the parties don't want to do.
Yeah.
Once the divorce is done and the equitable distribution matter is done, though, yeah, theoretically they could come back together, or maybe they start a new business
Yeah.
together. I will say this, I would highly advise that it not be 50-50 if you have ever been married previously.
Yeah, for sure, for sure. So, quick question for you. If I have clients that are asking me, Shawn, what's your advice on getting into business with your spouse? What's your family law take on that?
Family law take would be proceed with caution. And the only reason I say that is a marital relationship is a heavy burden in and of itself. It is not easy to be married. There's the emotional toll, the number of life changes you go through, the number of challenges you're going to overcome, hopefully together, is a lot on a relationship. And similar to how I tell my clients day in and day out, you can't expect everything out of one person. It's a lot to put on that marriage, also the stressors of running a business.
Mhm.
Now, I'm not saying it's not possible. I'm just saying proceed with caution because maybe it's the marriage that should be prioritized over anything else, including a business.
Mhm.
And if that is the take on having to choose the priority, maybe it's you get into business, but only one of the spouses own it. Sure, the other spouse can help and we can make sure that they have an interest in it, which, by the way, side note, if a business is created during a marriage and we don't have a prenup or postnup that states otherwise, then the interest in the value of that business is marital property automatically under equitable
Mhm.
distribution laws. What does that mean? At the dissolution of the marriage, under equitable distribution, it's presumed that the value of that business will be divided 50-50. So the other spouse's name doesn't have to physically be on, say, the operating agreement or a partnership agreement or the incorporation documents, because that's where the family laws provide protections.
Mhm.
Go one step further, then don't add both names
Yeah,
because you don't have to.
that's a good point.
And you might as well have one person owning it and operating it if they're going to invariably have one person running the gamut further than the other,
Yeah,
because the other will be focused on other things.
I like that.
That's at least my 2 cents.
I like it. I'll try. I'll try to have the conversations.
Sure.
A lot of times emotions get involved, and
Yes.
people want to have their name on the entity because people are excited. Another thing that I'll toss out there from the business law standpoint, I have clients come to me often when it comes to woman owned businesses and minority owned businesses, and I have clients who will ask me to form the entity and we'll do 51, 49% minority or woman owned. And then they'll say, now what? And I tell
Mhm.
people all the time, you know, it is good to start off on that foot if that's where you want to go, or you know that you really want to seek designations or funding with that already in mind. But these days there aren't a ton of grants that are just screaming in your face saying, hey, you're a minority owned business or you're a woman owned business, and so this is where we're going to get your funding from. And so I feel like I have that conversation with clients all the
Mhm.
time, and so I just want to toss it out there. I
Mhm.
100% support minority owned and women owned businesses, but I think that the days of funding are changing.
Yeah.
It's not
Yeah.
a reason to have your spouse on a business. I've seen that before too, where the husband's going to own and run it, and he makes his wife 51% owner just because of the designation.
Yeah.
And I would even say some of those grants, they've wisened up and they're going to look through the business. They're going to pierce the corporate veil a little bit and say, okay, well, what is he or she doing,
Yeah.
or what's going on there? And they're not just going to accept a operating agreement that was written on scratch paper with that anymore.
Yeah, yeah, and understandably so. Just because there's so many nuances in how a business can be organized and run,
Hmm.
and you can put someone on the face of a business all day, every day, and it could be just a picture on their website, right? And
Exactly.
it not be actually someone involved in the business. On the flip side, I my law firm is technically woman and minority owned,
Yeah.
and you see that on my website.
Yeah.
I don't have any designation though.
For sure.
You probably will call me after and say, "Hey, Teresa, here's some of the things," but and I
Yeah.
appreciate that, Sean. No obligation though.
Yeah.
But it's one of those that if you operate in your truth, it'll come back twofold anyway.
That is so key. And that's what I think. If anyone takes anything away from this podcast, you hit the nail on the head. Operating your business in your truth is key, because companies, institutions, they're going to pierce through whatever smoke and mirrors you put up. They're able to look through into tax returns, organizing documents, governance documents, and they can tell how a company is actually formed versus what you're telling them on paper. So, with your operating agreement.
That makes sense. Well, thank you, Sean, so much for joining us in the Legal Lounge. I do hope to see you again here.
Yeah, thanks so much for having me, Theresa.
Thank you for taking the time to listen to our discussion. To learn more about me and the Modern Legal team, go to our website, modernlegalnc.com, or check out the links in our show notes to follow us on Instagram, Facebook, LinkedIn, and YouTube. You can also call us at 704-286-6302. If you have been intrigued by the conversation and would like us to continue our discussions, please subscribe to the podcast and leave us a review. See you next time.